So your argument is that except for someone who has been convicted of a felony, a person may not be prohibited from possessing a firearm in the home. Is that correct?
I would add one more caveat to it, Justice Alito, and that is if severe criminal punishment will result, because that is something that Heller itself and Bruin itself took into this balance, because the right that's protected is the right of someone who, by keeping the firearm, is used for someone who's keeping a firearm for lawful purposes. How does this regulation infringe on that? If it is a small fine or even loss of the weapon, maybe that doesn't violate that right. You could make it illegal. You're prohibited from keeping a weapon. But if we figured out that you had a weapon in your bedroom, you may have to pay for it, but you're not going to go to prison for 10 or 15 years. You're not going to get felony liability. I think all of those things together are incredibly important about this ban, because it is not based on loss of rights of citizenship. It is applied against rights holders. It is a total ban, and it is punishable by an incredible amount of prison time.
So let me give you this example. Suppose the state judge determines after a hearing that a man has repeatedly threatened to shoot the members of his family, has brandished the gun, has terrified them, and orders the man enters a restraining order preventing that man from possessing a firearm any place, including in the home. Is that constitutional?
I think the answer is probably yes. If he did, I think it probably is. I would want to know more about what the historical tradition showed, but certainly courts have always had broad power against the people who are brought before them. And I think that would be consistent with the historical.
So the difference you see between that order and the prosecution for violating the order is the fact that the latter imposes a felony punishment.
That's one difference, and it's an important difference under this court's case law. Another difference is that the defendant had a real opportunity, in standing before the court to say either, number one, I didn't do that, or number two, something was wrong with me, I'll never do that again, and I'll move across the country so I can assure you that they will be safe, but I'm very frightened to be, without my arms. So you would have a chance to entreat with the person who's putting in the restriction. If the restriction itself was unlawful, the person would have a chance to appeal it to a higher authority, to an appellate court, and say, this judge got it wrong. This is not lawful either under the Constitution or under this state's substantive law. All of those things are different in the situation that you describe, and I think they are constitutionally significant differences between that and what we have here.